That letter from the Bureau of the Fiscal Service about wage garnishment is terrifying. If your hearing request is late, garnishment may continue for 60 days while waiting for a hearing decision. And that's not all. There is a clear legal process that can pause wage garnishment when handled correctly and on time. Many people don't realize they can request a hearing before a single dollar is withheld from their paycheck. We'll walk you through your timeline, your rights, and the specific actions that can help you stay compliant and keep control of your income, even during a shutdown. So, what are you actually facing? Here's how the Bureau of the Fiscal Service carries out a federal wage garnishment. It begins with a notice of intent to initiate wage garnishment, not an offset. You have 15 business days to respond, and missing that deadline can affect your income. The Bureau can take up to 15% of your disposable income, your pay after mandatory deductions like taxes. This is an administrative wage garnishment under federal law. State limits and exemptions do not apply. One piece of good news: federal law protects you from being fired or disciplined because of a federal garnishment. The notice you receive is your first and most important opportunity to act. Knowing your deadline and responding correctly matters. Your most important right is the right to request a hearing. This is how you can challenge the garnishment before it begins. To request a hearing before garnishment begins, you must act fast. Your written request must be sent within 15 business days of the notice date. If you miss that 15-day deadline, you can still request a hearing. However, garnishment may begin while your case is reviewed. In the hearing, you can challenge the existence or amount of the debt, or explain that paying would cause financial hardship. When your request is received, the agency opens a case and begins the review. Follow all instructions, keep copies, and respond to any document requests. A written decision is issued after your hearing. Timing varies by agency, so stay in contact until you receive the hearing decision letter. The hearing is your main opportunity to respond, but there are a few other valid defenses you can raise. You may claim financial hardship if paying would prevent you from meeting basic living expenses like rent, food, or medical care. You can also dispute the debt itself. For example, if the balance is incorrect or if the debt doesn't belong to you. If you've been with your current employer for less than 12 months and lost your prior job involuntarily, you may qualify for a temporary exemption from garnishment. Certain income sources, such as Social Security, SSI, and VA benefits, are protected from garnishment. If you owe the debt and hardship doesn't apply, negotiation may be your next best step. During the 30-day notice period before deductions begin, you can contact the agency and request a voluntary repayment agreement to avoid garnishment. If garnishment has already started, you can still request a hearing. Repayment terms are set by the agency that owns the debt. However, approval is discretionary and may not be affordable in every case. You have options: request a hearing within 15 business days, claim hardship when it applies, or propose a voluntary repayment plan. Timing and documentation drive results. Once a wage garnishment begins, you can still request a hearing. If you submit your hearing request within 15 business days, the Bureau of the Fiscal Service will suspend further deductions until a decision is made. If your hearing request is filed after the 15-day period, deductions can continue for up to 60 days while the hearing is reviewed. The hearing official must issue a written decision. If the agency needs more information, they will contact you before making that determination. To recap, keep every notice you receive, act within the 15-day deadline, and respond to any requests promptly. Timing and documentation protect your paycheck. Your options include requesting a hearing, submitting hardship documentation, seeking job-based exemptions, or asking the agency about a voluntary repayment plan. The message is clear. You are not powerless against a wage garnishment notice. You have rights, and you can take action to protect your income. Do not ignore the notice. Time is your strongest defense. Read your letters, track your deadlines, and get help if you're unsure what to do next.